Well, good evening, everyone, and welcome to the Raymore City Council work session for Monday, November the 21st, 2022. A couple of changes to the agenda this evening. We will be carrying over item A for discussion at a later time. Mr. Berenson is ill this evening, and I know that this particular topic is a passion of his and would like to give an input on this. So we'll carry that over. I know Mr. Gress is prepared to speak to some of it tonight if you have any questions, but we'll, would you want to make that announcement and let them know what transpired either today or I guess maybe Friday?
Friday.
Yeah.
Sure. So as the mayor mentioned, was looking forward to a presentation tonight to you all, but we'll keep the suspense going. One thing I was going to share that happened on Friday, though, part of the work that our department has done with Mark and their Community for All Ages, which is where a lot of this has come from or transpired. Our city was invited on Friday to participate in a group presentation in December for the Metropolitan Mayor's Caucus, which is an initiative of or a group that's spearheading the Age-Friendly Communities Coalition. Basically a group of cities that are working on similar topics with an emphasis on universal design. So Mark extended the invitation to the city of Raymore and 3 other communities that are participants of that program to be a part of that presentation to just share what it is that's going on in the city. I had shared with them that we were going to be presenting this potential ordinance to the council tonight, and they were impressed with that. So I'll look forward to hopefully reporting that back to them in the next couple of weeks.
Okay, thank you, David. Sorry we pushed that out, but there's a lot to talk about tonight with the second item on the agenda. And with regard to the third item, that is not Parks Board, that will be Planning and Zoning and Board of Adjustment.
Thank you, sir.
Okay, so we'll jump right into item B, recreational marijuana.
Thank you, sir. As the council is aware, Amendment 3 passed here at the November election, and that is going to require a number of future changes, multidisciplinary, as you can tell here, with the gang that we have gathered to have discussions on this. I want to emphasize to the council that it's early days for most of these departments, and so they will be waiting for guidance from their respective divisions at the state level. Should come as no surprise that the amendment passed, and now they'll start the trickle down of what does that actually mean for us. But in the meantime, we do have some early information and an early question that we need to ask the council relative to some upcoming council meetings and putting something on the agenda in the near term. Mr. Zur has volunteered to be the lead for this presentation, and he is the one who actually formulated the handout that's in front of you tonight. And so with that, I'll turn it over to Mr. Zur.
Thank you, Mr. Fearborn. I am happy to provide this report this evening for you. As you can see, we've got a handout for you, a little PowerPoint presentation. I will readily acknowledge that not all of the plants that you see included within this handout are, in fact, marijuana plants. So they're sprinkled throughout it in the course of it just to keep it a little spicy for this evening. Please stop throughout the course of the evening as well. I welcome any questions that you might have. I apologize. Chief Wilson just leaned over in my ear earlier and said, I am officially the gang leader. I'm not sure I qualify as the gang leader for this particular subject, but for tonight's purposes, I'm happy to have the conversation. We're going to cover a number of areas, as Mr. Fearborn had indicated. There's a number of areas that are going to be impacted by Amendment 3. Those are overviewed on the agenda, which is the second page, and that's going to kind of be the roadmap for our conversation this evening. First and foremost, I'm going to provide a quick overview of Amendment 3, what it does and what it doesn't do. We're going to have the opportunity to discuss personnel and human resources matters. Ms. Alger is going to be able to provide information on that, and with, I think, some additional backup from Mr. Murdoch. Police Department and enforcement provisions, I'm going to have some information on that as well, and Chief Wilson will provide his input. Ms. Davis is here this evening, court clerk, to provide us with the pending, past, and future court proceedings and how they're going to be handled by the municipal court. I'm going to provide a little bit of additional information on that one as well, and we'll kind of tag team that effort. Last, we're going to have Mr. Gress provide information regarding the code revisions that will be required. Maybe just simply inserting new definitions and terms within our current code provisions, but a lot of that is going to be based upon what we see come out from the rules and regulations that are going to be produced by DHSS on these matters. And then finally, we're going to have the opportunity to talk about taxation. I anticipate that Mr. Fearborn will jump in on that one. He'll be very excited to discuss the taxation options that are available for marijuana. Any questions so far? Okay, I'll dive back on to the next one, the overview of Amendment 3. The overview of Amendment 3 is really what it has done is basically has allowed for utilization of recreational marijuana in the state of Missouri by individuals who are over the age of 21. It creates a framework for regulating the commercial production, distribution, licensure, and taxation of businesses that are involved in authorized marijuana sales, and it allows, in certain circumstances, for individuals to do personal cultivation of marijuana. There are caps on what you can cultivate at your own home. There are also rules and regulations that are associated with how you can go about cultivating it. You can't have it out in the front yard. You can't have it in the front bedroom or front living room where everyone can see. There are additional revisions or additional rules that I would anticipate that we will see with regard to those. What Amendment 3 does not do is it does not allow for the public use of marijuana, so we can still have limitations on it as far as, hey, can it be used at the park? Can it be used at the skating rink? Can it be used at restaurants? Those are things that will have additional limitations placed on it, so public locations or private locations that have readily available general public utilizing them. You also have the operation of vehicles under the influence of marijuana, and this is going to be treated very similarly to operating a vehicle under the influence of alcohol. That's going to pose some challenges for our police force, and I anticipate that Chief Wilson will have some input on that. There is at least good samples, so we've got 22 states in the United States now that have had some form of this that would be allowed for utilization, and Colorado appears to have done a really good job of identifying how to enforce some of these provisions, and so we may be going back to their standards for adoption, but at this point we are yet to see those. And then you've got provisions: you are not allowed to use it in the workplace, and you're not allowed to utilize marijuana by any individual under the age of 21. That's the quickest overview of what Amendment 3 does and does not do. And I'll pause right there to see if there are any questions. Seeing no questions, I'll move back on. First item we've got on here is personnel. Personnel is going to be covering how we as the city are going to be adopting provisions that are going to change within our employee handbook. There you're going to be able to have certain limitations based upon Amendment 3. Those limitations are going to include employee positions that are directly related to federal funds, employee positions that are directly related to post-certified police officers, individuals that are related to public safety, and then also individuals in the city staff that maintain and utilize a commercial driver's license, which are still not allowed under federal guidelines for purposes of being able to drive under the drive and utilize marijuana. At that point, I'll hand it over to Sean and Mr. Murdoch and let you guys decide how you want to take this portion.
Well, you said most everything I was going to say, but so obviously our drug-free work policy is out of date in our handbook, so we will be moving forward pretty quickly to make that change as it refers to the Missouri statute for that, which is now out of date. As Jonathan indicated, we do have some guidance as to, obviously, you can't be under the influence during working hours. You can't possess, you can't sell, you can't be under the influence during working hours. And then if you test positive, there is guidance that indicates if you test positive and you're post-certified or you have a CDL license or anything that would prevent us from receiving a federal grant, that we do could have grounds for termination for that employee. Or on the flip side, they would not be eligible for hire if they are drug testing for a pre-employment position, either for a police officer or other safety-sensitive positions, or public works.
What we can't do under it is discriminate in either the hiring or the termination for a positive drug test, unless obviously it's going to be going for one of those identified employee areas that are going to be more closely regulated for it. And we cannot restrict them or impact them, discriminate against individuals who are using during non-working hours or who are qualified patients or primary caregivers. So if those are the standards that are going to be applied, we could not limit their ability to be employed here in the city based upon those provisions or a positive drug test from it. So staff will be continuing to work in identifying the provisions of the employee manual that will need to be changed. And Mr. Murdoch, if you'd like to jump in.
Yeah, so in a call, just to kind of as a summary too, speaking with the legal team that handles most of our HR cases, one of the highlights of that phone call was essentially that if we wanted to, our current policies essentially could stay the same. That Amendment 3, in essence, wouldn't necessarily require us to change anything. That's not necessarily our legal team's recommendation to us, but hopefully that allows us some of that flexibility that we would need in terms of what Ms. Alger was saying, in terms of dealing with our post-certified officers, our CDL drivers, that kind of thing, that we will have some flexibility in how we address our policy handbook, and then also within our standard operating procedures within the police department and other departments that handle that, because that's where some of that language is also going to have to be changed. The other thing from that phone call that was important was to know, after it becomes legal here in early December, and we start seeing some of the challenges to it, that's when we're probably going to know where either some gaps might be, as we can't predict everything that is going to happen, obviously, here over those first few months of it becoming legal. And we'll continue to get those updates from that legal firm as to how we can have a best practice in addressing Amendment 3 throughout all of our policies.
Anything further? Any questions with regard to this particular item?
I kind of felt like one of the overarching really good statements at this early stage is in this very first part of your handout, and the fourth page actually talks about what about personnel, and the very last paragraph of that really sums it up well, that we can continue to have a drug-free workplace, just as we've always described it, what we currently have in policy. The two areas that we're going to have to be cognizant of are if we run the risk of losing funding, monetary gain, and or if we run the risk of losing a licensing, CDL, post-certified personnel, emergency management personnel working for us. Those are two areas where we can continue to have the same strict policies that we do have as far as a drug-free workplace. We recognize that down the road, people who don't fall into those categories, we're going to have to take a look at. We actually talked about if we continue to hire administrative assistants, let's say, use that as an example, without testing or without having any sort of more stringent requirements, because this is a federal law versus a local law now issue, do we run the risk of losing previously received funds, like the over $4 million in ARPA funds that we have sitting in our reserve fund? We do not think so. That money has already been received. It is already earmarked. By the time any of this gets settled, it will hopefully have already been spent. So in that sort of a case, we do not feel like if they would find us to be in some sort of a federal violation, that we would have to return those funds.
I also anticipate moving forward that we're going to see the legislation coming out at the federal level. It's going to be very clear on whether or not there are drug-free workplace requirements that are going to be imposed in order to receive those funds. So it'll probably be relatively easy for us to identify, hey, is this something we can receive based upon our current drug-free workforce policies that we've got in place? Any other questions? Okay. Moving to our next one, the police department and enforcement, and I'm going to try and not steal all of Chief Wilson's thunder here, so I'll let him go ahead and just discuss it, and if I need to fill in anything further, I can do so.
I'm going to agree with Sean. Obviously, Mr. Zur read Amendment 3 to you earlier and covered many of the items that I would talk about as well. But for the police department, it's not going to change a whole lot for us right up front, other than we need to take a look at the city ordinance for possession and drug paraphernalia. Obviously, with the Amendment 3 ounces is what you can have in your possession. Our city ordinance basically says any So we will be moving forward and bringing some amendments to the ordinance before the council for both items. The paraphernalia talks a lot about marijuana in it as well. We'll be updating that. We'll still have paraphernalia ordinance to include other drug paraphernalia as well. We just have to take a close look at, you know, the marijuana portion of what paraphernalia is. And then we also, as Mr. Fearborn said, we'll be getting some other guidance from the state as well and the Department of Health as time moves on. Initially, some training within the police department, you know, the difference between a joint and 3 ounces is quite a bit, and what that looks like. Right before we started, I posed the question to Mr. Zur. I wonder what, if I had 3.5 ounces, what's that gonna be called? Is that gonna be called a misdemeanor? Is that gonna be called a felony? Or what is that gonna be called? More to follow with that once we get some direction from the state.
As well as 3 ounces of what? 3 ounces of lemon bars, 3 ounces of gummies. These are just things that have been told to me that marijuana gets put into.
And sir, I actually think that there has been some clarification even in the last few days in regards to that one in terms of its non-edibles. Like edibles don't fall into the category of the 3 ounces, according to what our one attorney has told us.
The language of the amendment was stating that it's all based upon 3 ounces of dried leaf weight of marijuana.
Right.
And so how you correlate that to whatever it is that's being purchased, gummy or otherwise.
But I think some of that will also come down from the Department of Health here in the near future. I mean, if you jump on their website and look at some of the rules and regulations for medical marijuana, you'll find some of similar verbiage listed, and I think they're going to adopt some of that and bring it over to the recreational.
One of the, and again, overarching in the PD area that we discussed as we were going through this presentation for tonight is under 21, you're in violation no matter what. If we pull somebody over, you can't have it if you're under 21. And then the same way you think about alcohol when we're pulling somebody over, open container rules apply. It cannot be in an open container. It can't just be on the front seat of the car. You cannot have something that you're obviously been smoking or ingesting just sitting open in your cup holder in a situation like that. It has to be in an approved sealed container.
Yes, Mr. Burke.
Thank you. What about in the case where there's a car and one person has, because you can be under 21 with medical card. You can be 18, 19, or 20. So
The difference,
we're going to have to figure out all the.
well, within a car,
the
we're
state.
still going to be looking for, you know, if their driving is impaired,
Right.
if they're under 21 and they have a medical marijuana card, they should have it with them as well.
Right.
But there shouldn't be any burnt marijuana in the car that, you know, when we go up to approach them and they roll down the window and all the smoke rolls out, you know, that's a telltale sign.
Right. But
So
it's
we'll
21
still-
is not
We'll still be investigating.
always.
Yeah, and this evening we're strictly speaking to adult use recreational marijuana.
Under that same line of thought, you do have the provisions with regard to odor. So if an officer comes up to the vehicle, in normal passing situations, the odor of marijuana is not in and of itself a justification for further search, arrest, or otherwise. But if it's a suspicion of operating under the influence, the odor can be taken into consideration for that. You also have that no conduct that would be permitted as far as smoking is concerned or ingesting is a basis for detention, search, or further arrest unless it's in affiliation with further crime or an alternative crime. And the officers will be required to ask with regard to their ID cards as well. So that'll be an additional provision that'll get adopted. Anything else?
You covered it.
Sure. As far as cultivation at home, and I'm going to stop here real quickly, and we'll come back to it a little bit further on down the road with another one of the slides. 3 ounces is the magic number as far as this is concerned. There are also provisions with regard to in the home, so it cannot be visibly cultivated. You can't visibly cultivate the marijuana at home. You can't cultivate it in an unlocked space, and you can't consume, transport, ingest, smoke, or do anything under that age of 21 under the adult comprehensive analysis for it. You could do so under the medical side of it. And for operation of the vehicle, part of what is being presented here, at least what we are seeing, is some standard being applied. In Colorado, there's a standard of 5 nanograms of THC in your system. If you are above that 5 nanograms, you are therefore identified as being impaired by it at that point. Less than that is not impaired. But how they go about testing that is going to be a challenge.
Yeah, that's gonna be a new procedure for us. I mean, we'll obviously have to apply for an affidavit and apply for a search warrant and, do a blood draw search warrant, and get somebody's blood and present to the lab. That's the only way we're gonna be able to determine how many nanograms are in, of THC are in someone's system.
Jay?
Implied consent wouldn't apply.
Yes, it would.
You would need an affidavit. They've got to do it or they lose their driver's license.
If they're, well, I think that it's gonna end up as similar to DWI. If they refuse, then we would
Exactly.
apply.
Yeah.
But that's more direction to come from the state, I'm sure, down the road.
So the blood draw seems intrusive to me, but is urine no longer a testing fluid that they can do?
I apologize, I don't know that.
I don't think that they can get that off the urine. I think it has to be a blood, but more to follow. I'm not real sure on that as well, but I'm pretty sure that they're not gonna be able to get that out of just urine.
Did you say you were going to talk more about home cultivation?
Yes, I will.
Okay.
Yeah. Other questions with regard to the police department, current enforcement, searches, warrants, or otherwise? Don't drive impaired.
And if you have a home grow, you'll have to have a permit.
Yes, you will. You'll have to have an ID card. That's okay, moving on to our next slide. Pending, past,
Do you
and
have a
future
excuse
court
me?
proceedings. Yeah.
Do you have a question?
You sure? Yeah.
So back to the blood draw versus whenever someone goes to get a job, don't you normally to like drug test them? Don't you normally have to pee in a cup? So wouldn't that work or no?
Yeah, that's gonna work for a positive hit, but it's not going to tell you the
How
exact
much?
amount.
Got it.
Gotcha. Okay.
I apologize, sorry.
Okay.
So if they refuse and they lose their driver's license for it, and then you apply for an affidavit and a warrant and all of that, then how long would that process take to do something like that? Because if it ends up being like 12 hours or 24 hours, then wouldn't the results be skewed?
Well, so I would imagine how this is gonna play out is similar to an alcohol refusal. They refuse to do any kind of test. We do an affidavit, get a search warrant. Once the search warrant is executed at a hospital, probably within 3 hours or so, typically is what that takes. With alcohol, it's a little bit quicker. And again, I'm speaking out of turn. We do driving while drugged now, so I'm assuming it's gonna be similar to that now, but we'll see what the state has to say here in the near future.
Did you have something, Ryan? Okay.
The next slide we're going to look at is going to be with regard to court proceedings. Ms. Davis is here to join us with regard to that, and I'm going to let her provide a little bit of overview with regard to the current numbers that we're dealing with. I did have the opportunity, Judge Nigro is not here this evening, but I did have the opportunity to reach out to him prior to this and have received an email back from him. I believe we've shared that email as part of the packet of materials as well, so it's right after the article, so you'll see the response that was provided. I'll do a quick overview of that so that you don't have to worry about reading through it at this particular point. But for past purposes and an expungement, there's the opportunity under the amendment for expungement of prior convictions. Judge Nigro is taking the position, and I believe it's an accurate position, that the circuit court is going to have to be called upon in order to do expungements of any prior convictions that you might have out there. Though no reference within the terms of the amendment for the municipal courts to be able to do that. With regard to the past events and pending events, Judge Nigro has requested our clerk to go through and identify all of the current possession and paraphernalia charges, convictions and probations, and they're going to be forwarding those to the prosecutor for potential dismissal. That is with regard to current pending items that are before the court at this time. There's some thought with regard to whether or not you could still go back and collect court costs. The citations were issued. The simple fact is, at the time when the citations were issued, it was a violation. Still a pending violation. If you're going to get pulled over at this time, you're still going to get written a citation, I would anticipate. What the court does with that is a different story, and that's going to be up to the prosecutor and it's going to be up to the judge. If they proceed forward on it, ultimately you get an answer from the judge regarding, hey, was it a violation, was it not a violation, am I going to convict you of something or another, and then immediately thereafter, after December, we've got the opportunity for expungement through the circuit court. So from a practical standpoint, what's the benefits of getting us to that time frame or that place? And I think that's what the judge and the prosecutor are looking at doing at this particular time. Obviously, we don't intrude upon the prosecutorial discretion, so it's going to be within Mr. Marshall's determination as to what he prosecutes moving forward. But that is kind of the sense that I'm getting from the email from Judge Nycro. Under the future enforcements, you will absolutely have enforcement for individuals who are utilizing, that are under the age of 21. You're absolutely going to have provisions with regard to under the influence, and that will be enforced very much like alcohol is. And then there's also going to be cultivation limits and exceeding the cultivation limits that you're going to have. Hey, we're authorized to have 12 plants and 12 clones and 12 flowering plants at our home, and instead we've got 150 of them in our basement. Those are going to be excess violations for cultivation that we will be able to enforce. And again, I believe that's going to be enforced through the police department, not through our codes department. It's a criminal act at that point. Is that right?
That's right, but I think at this point, we still don't know what that's gonna look like. I'm sure the health departments are gonna send out that it's gonna be an administrative violation. However, you know, something from the state has to come down describing what 20 plants are.
And again, cultivation is going to require an ID card in order to be able to do that. Okay. It will require code changes. We'd anticipate bringing that forward to you all for consideration. That'll be code changes with regard to the use and paraphernalia crime, as well as provisions regarding public smoking. So I would anticipate having them come before the council at some future time frame for adoption of revisions regarding those particular criminal acts. Any questions with regard to that so far?
So I had a question about the expungement process. So our officers arrest an individual for possession, and they pay a fine and court cost and or pay a fee to go to ADP for a rehab class. Are those fines recoverable by the individual if expungement is allowed?
I don't believe we've got information on that at this particular time. And in fact, Nigro's comment is specifically that he's waiting for additional information from the presiding judge about what they are capable of doing under that expungement provision. So,
Well, that would be a big brouhaha.
it would be a very difficult task for refunding
court,
individuals
yeah.
and doing, yeah, absolutely agree. I don't anticipate that it will.
I don't know that we have a lot of that. It wouldn't be like a DUI or running a stop sign or something like that if they made that legal.
Yeah.
But it is interesting to see what kind of complications come out of this.
Sure. And to give you a sense as to what the court is dealing with, I'll turn it over to Ms. Davis and let her provide information regarding some of the numbers that we are dealing with currently and what she's done so far with regard to the judge's request to identify past convictions, past probations.
All right, so mine, my paper is on the last page. It lists the marijuana and the paraphernalia, and then it breaks it down by no convictions and convictions. And then the ones that have been paid in full, they've currently shut down, where we are not able to run reports or get any numbers that way.
That's the last page. I see you all slipping
Yeah.
through the PowerPoint. It's the
Amendment
last
3?
page.
Yeah.
Yeah, it's the last page of the, yep, that's it. The article.
This one here?
Yep.
Okay,
Apologies.
thank you.
And then on the bottom of that, it does show like what the Office of State Court Administrators have said on November 9th. They said that pretty much just to watch for more information from OSCA in the coming weeks. So we have no more answers on what we're supposed to be doing.
And in fact, they basically stopped your access to a number of these
Yes.
items too. So
Yeah.
fill them in on that.
Yeah, so I can't run any reports. Like I had to physically pull all the active cases by hand. Couldn't run a report to pull them all in. And so that's how I got all my numbers by pulling all of them. I pulled all the warrants that are currently in warrant status. If they've already been convicted, there's a bunch of them still like on payment plans. That's why they're still active. There's, 13 marijuana charges still, they've pled guilty, they just haven't paid.
So the convictions in the old court record system that you see in there, those would be up to potential expungement. That is going to go to the circuit court level. Anything prior to that for the total cases in the show me court system, you'll see those are the cases that will likely be impacted by changes to amendment with Amendment 3. Okay. It will have an impact in our municipal court. Hopefully it will not be so much of a disturbance. I know that you feel like it has been already, but hopefully when we hit the ground running with it, judge is going to have further input from the presiding judge here in Cass County, and that'll help the process move forward a little bit. Again, we're still kind of just dealing with hey, here's the amendment, it's going to drop in your lap, and by the way, it's effective as of this date. Questions about that? Okay. I'm going to then have, yeah, sorry.
So this is for the whole state of Missouri, but I mean, what directly impacts us? Like here in, is it Cass County or Raymore?
This is the city of Raymore.
Oh, this is just Raymore, okay.
Yep.
These are
Sorry.
just the city of Raymore citations that have been issued and the convictions that have been issued. These are Ms. Davis
Yeah.
going through all of her records, both physical as well as capable online, to identify any of the prior citations that have been issued for paraphernalia and possession. She's gone as deep as going further into it to say, hey, it's paraphernalia, but the item was issued as a meth paraphernalia as opposed to a marijuana paraphernalia. And that'll be for consideration by the prosecutor and by the judge in determining whether or not they proceed forward with the prosecution of those cases.
And these date back all the way up to, from 1997, that 487 of marijuana charges in the old INCO system, that's how back far it goes. A long ways. And that's why there's so many.
The next item under this section I'm going to have you look at, and it's going to cover our cultivation. Yeah, I'm sorry.
So, in the rare instances where possession of marijuana was the original clue to the incident which led to something more serious.
No longer an ability for that one.
Right, but past case, I see him smoking a joint, I make the arrest, and I find out that he just robbed somebody down the street. So you got a felony conviction for armed robbery, but your initial PC was a crime that is no longer a crime and can be expunged.
That poses a problem. That's
Yeah.
exactly correct. And the language is clear that you can't use anything affiliated with the legal use of marijuana, what is now a legal use of marijuana, for determination of a factor moving forward.
Right, I just didn't know if that's going to vacate past.
That may be the
Other
basis for the
crimes that-
expungement provisions.
Yeah, okay.
But I would say if there was possession of 3.5 ounces, it would be a go.
Yeah, there you go.
The next page that you're going to look at there, it's the page right before the last page. So Ms. Davis showed you the total cases in the show me. The next one before that is the Amendment 3. And this is an excellent piece of work that Ms. Davis put together for us that covers 9 areas that if you're looking for a real easy cheat sheet on what does it mean from a criminal standpoint, what does it mean for a fine standpoint, this will cover it for you. So basically, you must be 21 years old in order to possess, use, ingest, inhale, transport, or deliver marijuana. Obviously, if you've got your medical ID card, there are provisions that would be separate from that, and you must be able to present your valid ID in order to prove that you're 21. You cannot have a requirement that they be any greater amount of IDs. Your normal driver's license, as long as it's a valid driver's license, would be sufficient. That will carry, if you are in violation of it, a $100 fine or the option of a 4-hour drug education class. It's going to be charged as a minor under possession. Next one is going to be an open container of marijuana. Again, I'd go back to Mr. Fearborn's comments on this. It's going to be treated very much like an open container as far as alcohol is concerned. It's going to be, it's got to be a sealed container. If it's in the car and it's in transport, it needs to be sealed. It can't be open and used. And that'll be justification for issuance of citations for an open container violation. Again, similar fine to go along with that, I would anticipate, but it's not yet been specified specifically under the terms of the amendment. As far as purchasing is concerned, you're going to have your limitations of 3 ounces. Purchasing, possessing, consuming, using, ingesting, inhaling, processing, transporting, and delivering. You can only have the 3 ounces at home unless you have the other portions of it locked in a separate box, and you can have 3 ounces at another location. Again, no specific fine has been identified for this, and it's going to be possession of marijuana over 3 ounces. That's where we get back to the conversation as to, okay, is it 3 ounces of dry leaf weight? Is it 3 ounces of gummies? Is it 3 ounces of lemon bars? Smoking, yep, I'm sorry. I thought I heard someone. Smoking marijuana in a public place, we anticipate that we're going to need to amend our ordinances in order to make a specific reference with regard to this, but that's going to be concert venues and otherwise. Again, you're going to have a fine that'll be up to a $100 fine, and that'll be a charge that will be coming down the road for smoking in a public place if we're going to have that. Now, we have adopted the smoke-free Raymore, did that a couple of years ago, and the question is going to be whether or not this is going to be applicable to the same, or if we're going to need to expand that provision. Okay?
Yeah, what's interesting is that Raytown it never designated themselves as smoke-free. As I think there were 3 or 4 other communities in the state that did that. So they're having to go start from square one, moving forward to order to restrict smoking in public places.
Yeah, it was interesting, and I'll share a little bit more when we get to the later slide. Today we had the opportunity to participate. I had the opportunity to participate at the Chamber of Commerce and Independence, a meeting of a group of metro communities that are coming together in order to discuss about the campaign for the taxation, making sure that, hey, are we using the same campaign materials so we have cohesiveness amongst all of our jurisdictions. It was interesting to see the differing locations where the municipalities are in. So Kansas City currently has an ordinance that they've had their first reading on last week for the taxation of marijuana under the adult use. They will do their second reading this coming week. Raytown has a proposed ordinance in hand that they are working with, many of them coming off of Kansas City's provision, and we will be presenting to you this evening a proposed ordinance for consideration as well. The rest of the communities that were there kind of catching up as far as I'm concerned. Hey, what do we even do here? Sugar Creek was actually pretty good. They showed up, and they don't have a dispensary in their community at this time, but they are all on board with making sure that they have the tax provisions available and the other ordinances in hand, so that if and when a dispensary does come to them, they're not, reactionary as opposed to already having it on their books. But I'll get to that a little bit further down. Following up with regard to the Amendment 3, smoking marijuana in a public place, obviously we're going to have to alter our charges for that one based upon our smoke-free environment and whether or not we need to amend our code for it. DUI, operating a motor vehicle, this is important. Any vehicle at all whatsoever that you would be operating. And I would anticipate, Chief Wilson, that that would include our low mileage vehicles as well.
Yes, sir.
Very good. So our low mileage vehicles would also be included within that for operating under the influence. Important to note that CDL holders cannot operate a commercial vehicle while under the influence. And again, I go back to the Colorado with the 5 nanogram provision on this one, how we go about testing that. We don't have a specified, yeah?
Mr. Zer and I working on a Saturday to try to clear this particular paragraph up, and this is what you get when the city manager and the attorney are trying to clear something up. It just doesn't seem to work. The CDL holders is separate and apart from the rest of this particular paragraph. No matter what, CDL holders can't have any kind of substance tested positive within them, no matter the level. The 5 nanograms applies to anybody then over and above that. That is considered driving under the influence in Colorado. All of the discussions, I think, today with the entities that were together, it is looking more and more like Missouri may be going to that exact same standard of the 5 nanograms.
Absolutely.
Sorry, sir.
No, you're good, you're good. And if that's the only correction that needs to be made, then we actually did work pretty good together on a Saturday. Current medical marijuana dispensaries, they can continue to utilize the medical marijuana dispensaries. However, they can apply for a licensure that will be identified for a comprehensive marijuana dispensary facility. That's the, hey, it doesn't matter if it's recreational or it's medical. Mr. Gress will probably be able to provide a little bit more on this one, but I'm happy to fill in. They have added multiple definitions, 4 additional definitions, including micro business for marijuana use or for marijuana sales and distributing and manufacturing. They've added additional provisions for licensing that would go along with it. Hey, how do you qualify yourself? Are you transporting marijuana? Are you dispensing marijuana? Are you manufacturing the non-leaf substances such as the lemon bars or otherwise? All of those are going to be included, and they all will be able to be identified for licensing purposes as well. The language is consistent throughout as far as the 3 ounces of dried unprocessed marijuana per day. I'm not sure if that means that you can only do it per day from that particular dispensary, or if you're going to be able to shop around and get multiple. It would seem to me like the intent was going to be 3 ounces per day, but they're going to have to make sure and tighten that up with further regulations and rules as far as I'm concerned, and who's going to be tracking that, whether or not there's a computer program maintained by the state as to note you've already been in 3 cities over, and so therefore we're not going to sell to you at this point.
I would imagine that will come down through the Department of Health with some of their regulations once they develop them. I mean, you know, when they did the medical marijuana, it took some time to get those in place, and I would suspect it'll be the same.
With regard to current, the plant options and the cultivating options, again, the language is talking about 6 flowering plants that you can have in your home. If you've got your ID card, you can have 6 non-flowering marijuana plants, and you can have 6 clones. So 18 total along those lines. If you have 2 individuals in the home that would have ID cards that would go along with it, you can essentially get double that number. So, but you can't go beyond double that number. So if you've got 18-year-old kids in the house who also happen to have an ID card, they can't have more than those double the 18. So I think that's what you're looking at as far as those are concerned, and that's the last item you'll see on there. For the first violation, the fine is $250. Second violation, $500. Third violation is $1,000. And again, under the 21, you've got $250 as provided. And they can do a community service in lieu of that if you're inclined to do so, perhaps a community garden.
Jonathan, so being married to a Chamber of Commerce president, I get access to crazy information. She gets an actual journal that the marijuana industry puts out. And they talked about Amendment 3 in there, and one of the provisions in there on what Amendment 3 does and doesn't do, talked about for recreational purposes, you can cultivate up to, they said 8 plants. Was it 18 plants?
So
as your numbers add up to?
They
I was
show,
thinking it was 8 plants for recreational purposes, and you can gift up to 3 ounces.
I believe it's the 18. I think you're looking at the 6 flowering plants, 6 non-flowering plants, and 6 clones are your max numbers for them.
Okay.
And I am happy to look further at that if you would like to, Your Honor. If you've got that documentation, I'm happy to take it.
Same numbers they use for medical marijuana. Same
Yeah.
exact numbers.
All plants and all marijuana produced in plants in excess of 3 ounces in the private residences must be kept locked, not visible for and by normal unaided vision. And again, if the officers walk in and they see, hey, we've got multiple plants here that are far in excess, or we've got more than 3 ounces in excess showing, you have the ability to write a citation for that, and the fine is going to be $250. Yeah.
Go ahead, Mr. Townsend.
Thank you. I think you just answered my question. So these can't be grown in the backyard, even in a fenced yard?
I think the implication here is that they're going to be inside.
It actually refers to that it has to be within the residence and not visible.
Yeah.
Will our code have to be specific to that language?
I believe it's going to have to be.
Thank you.
I would like to thank Ms. Davis for putting this together. She did an excellent job of going through the amendment and identifying each one of those fine provisions, and she made it very easy for us for these purposes. Very easy and quick cheat sheet if you've got neighbors or constituents who are asking what can and cannot be done.
And I would agree with Mr. Zer on that. A number of the folks who have called me already, these are pretty simple answers. Anything, how many plants can I have? That sort of thing is what we've been hearing in the early stages. Anything beyond that is because we're still waiting. And so.
Very good. The next slide that we're going to cover, unless there are more questions about yes, Councilman.
I have 2, thank you, sir. So the first, I'm assuming this does not provide for, and it would not be allowable to do online sales. Is that a correct assumption?
Actually, I believe you can do them in the state of Missouri as long as it's to a location in the state of Missouri and they're able to do some type of a confirmation.
I see. And then the second question would be for Chief Wilson. So it's all in effect. You go out and decide to get froggy and light up a box truck, and he's got 300 pounds or bales. What do you do? Call the DEA? Because over 3 ounces, yeah, he went way above that, but that's trafficking. I mean, do they still, I assume we're going to go with the feds on something like that.
Well, there's still the ordinance or the state statute for distribution. you know, we can maybe swing it that way, but there's always the DEA route as well.
That's what I figured.
We still don't know what 3.5 ounces is gonna be called, whether it's gonna be a misdemeanor or what
Right.
have you. I don't know what it's gonna be called, so.
Yeah.
But we do have some avenues.
Yep, thank you.
The next slide that we're going to cover is going to be code revisions. Yeah. I'm sorry.
She said, never mind.
You sure?
Someone else?
I was just curious about the plants, so they have to have a card to be able to grow. And is that something we're tracking here at the city? So this is gonna have more, where we have to,
Anything like that's going to be issued through
State.
the State Department of Health,
Oh.
and it'll be just like a driver's license. If we, when we pull somebody over, if they have a closed container in there, they're gonna have to show us the card that's been issued. If we're going into someone's home, same thing, do they have a cultivation card that's been issued by the Department of Health?
It's my understanding they don't actually issue cards. I don't know about growing, but the medical cards, I don't think they actually give people anything.
The language from the cultivation information is that they will have a card that will be issued to them that they will be able to present if an officer approaches and sees that, hey, we've got 150 plants in the basement as opposed to something else.
So I'm talking about I don't know, maybe nobody, medical cards here.
The medical cards you can get online now.
I don't-
Anybody can jump on the Department of Health's
But I mean,
website.
I don't think they actually print anything.
No, what you do is you get on their website, fill out the proper information. I think you can pay your dues, whatever they may be, and then you can print it off. They'll email it to you, you print it off.
So you could just have a piece of paper folded up and, okay, interesting, thank you.
I've not
But-
seen the.
But the Department of Health also keeps a database of it. And in fact, when we were talking about somebody going and buying at a particular location, and again, trying to focus here on the new law, not the whole medical marijuana thing, we're having trouble enough getting through that one. When somebody buys at one of these dispensaries or whatever the outlets are going to be called for recreational marijuana, they're obviously going to have to produce their ID. They're going to be entered into the databases having purchased up to 3 ounces at that particular location. Now they're in the database for that. How is that going to impact somebody who then goes home, drops that off, goes to a different dispensary or outlet where is that going to impact whether or not they can buy another 3 ounces, and then how much can they have total, and is there going to be a period of time where they're assuming that the 3 ounces has been used up and you can't buy another 3 ounces? All of that to be determined.
Yes, sir.
Oh, go ahead.
So back to my question about online sales, you still got to get it somehow. You can order it online, but you can't send it through U.S. Postal Service. That's going to have to be either Uber marijuana, or you're going to have to go pick it up somewhere, right?
That's correct.
Somebody's going to have to courier it.
That's correct. I would anticipate you're going to see very much like maybe I shouldn't use the example. You're going to see very much like I'm going to order online and pick up at the brick and mortar store.
Yeah, that's what I was going to say. It's about the only way you could really probably do that.
Yeah.
Thanks.
I just was gonna say that I think that some of the places do deliveries.
There is contemplation of deliveries, I think, but that still has to be delivered to an individual who's over the age of 21. And there is language within that establishes transportation facilities for purpose of being able to make that kind of transportation.
And they have to have a card to transport any marijuana.
Other questions? The next page you're going to see is going to be with regard to code revisions. I'll let Mr. Gress speak with regard to this one, but basically, the city still has the authority to impose time, place, and manner limitations with regard to the utilization. In particular, local governments are able to put distances between certain business entities and the marijuana dispensaries or the marijuana industry facilities. They cannot be unduly burdensome. And the language for unduly burdensome is the subject licensees or potential licensees, they can't hold them to such a high investment of money, time, or any other resource or asset that a reasonably prudent business person would not operate the marijuana facility. So that's going to be the standard by which we are adopting any code provisions that would say, hey, you can't have a marijuana location anywhere within X number of feet, or you have to have a license agreement. And that license is going to be 90% of what your profit is going to be. We can't impose those kind of burdens on them. I'll let Mr. Gress comment with regard to the other.
Thank you, sir. Great segue. As the council may remember, the 31st Amendment is what was adopted by the council to provide for the provisions that regulate medical marijuana facilities in the city. I wanted to touch on a couple things since the questions were asked. For the most part, this section of the UDC only regulates the commercial operation of these, so it doesn't really get into what you do in your own home. That would be more city code with the police department and so forth. But relative to the cultivation facilities right now for medical marijuana, outdoor cultivation is allowed, but it's a conditional use, so the council has to give their approval for that type of cultivation facility. There are provisions.
That's not for residential cultivation, though.
Correct.
That would be a
commercial
endeavor.
operation, yes, absolutely. Relative to a transportation facility, so a company that would transport the marijuana from a cultivation facility to a dispensary, there's specific licenses for that, provisions where those types of facilities and their vans and such can be parked within the city. So I would say of the gang here, I think I have the least work to do because a lot of this has already been put into the code. In case the council isn't familiar, relative to from most restrictive to least, a outdoor medical cultivation facility has to be 1,000 feet away from an elementary school, daycare center, or church, 1,000 feet from a residence, all the way down to a dispensary, which is 500 feet from an elementary school or a daycare center and so forth, to 100 feet from a residence. So from the research that I've seen from peer cities, the majority of cities are kind of revising their current language to reflect kind of the comprehensive would be medical or recreational marijuana. The code has already generally decided where marijuana can be sold or cultivated within the city. So the next step is to take whatever new definitions may come out of this legislation and update that. The one thing I noted for probably future discussion would be taking a look at our sign code. Right now, relative to dispensaries, I think the only thing they can display would be the word dispensary. The green cross, which you can see is a common occurrence. They can't display any signage on the outside, which would be like the infamous leaf that you would see. It's on our department's list to look at our sign code comprehensively in the next year anyway, so we'll probably lump some of that in there if there are any changes that come down from the direction from the state.
Two questions, and not intended for purposes of trick questions for you, David, but advertisement for special sales or otherwise?
I do not believe is allowed.
There you go. And then the next one is the how the measurement of distance is taken from the dispensary or from the facility to the location that would be a disqualifying location.
So ours is majorly as the crow flies, a straight line without taking into consideration any other buildings or blockages within that. Other cities have crafted it to where it's the path of most common path traveled, whether you're walking or driving. But as it is right now, that distance is measured basically from, depending on the type of facility, if it's a standalone, it is from the property line. If it's in a strip retail center, it's from the front door of that facility, but generally to the property line of something adjacent to it.
And that was part of the discussion that occurred today. A number of the cities are looking at this. I think the language from the amendment would allow it to be from the nearest access point of the building to the nearest location of the disqualifying item. So walking out your door and walking a legal route, not through private property or otherwise, but over sidewalks to get to the playground of the school, for example, that is the determinative distance that they're doing it. We have it as the crow flies on our particular provisions, but that was a discussion point today. Questions with regard to code provisions? No? Moving on to our last section, we have taxation. Under the terms of Amendment 3, the city is authorized to impose a 3% sales tax.
This long legal sheet with the 2 yellow highlights on it for y'all.
Local governments are authorized to impose an additional sales tax in an amount not to exceed 3% on all tangible personal property retail sales of adult use marijuana. Some discussion has occurred as to whether or not this is going to be applicable both to the medical marijuana as well as to the adult use recreational. The consensus of the conversation today was that it was going to simply be adult use for recreational, not to apply toward the medical. We have provided or will be providing a sample ordinance for you all to consider. Obviously not voting on anything this evening. We have drafted our sample ordinance to adopt the 3% sales tax, and it would go to, basically, you have to have it approved by the voters. So you all would vote potentially to have it placed on a ballot for a 3%, and then on the ballot, which would come up for your April election, voters would have to approve it by a majority vote to have it be instituted, or to allow you guys to institute that 3%. This afternoon, I did have the opportunity, like I'd indicated before, to participate in a Metro-wide meeting for campaign efforts coming up. The cities represented included Raytown, Raymore, Liberty, Kansas City, Independence, Blue Springs, and Lee Summit, all of whom are looking to put this onto their April ballots, and they were looking to be able to do so with some continuity of message and continuity of efforts. All of them have dispensaries within them that will likely be looking at going for the comprehensive licensure that would allow for recreational sales. All of them are looking at this. Just to give an example today, the City of Independence has identified Fort Collins. Fort Collins, Colorado, in the 4th year after instituting it, had received sales tax revenues in approximately $3.9 million, and they were a city of 168,000 individuals. So I'm not sure exactly what it will ultimately mean from a financial standpoint for the cities of the smaller cities, but that's the example, one of the comments that was thrown out for it. We do have the sample ordinance, and again, it would have to be approved by the voters.
Couple of items relative to this long sheet of paper to touch on with the council. Item B is also a source of revenue that you see at the top of the page. I have very little hope that, since it does outline by appropriation, that we will see any kind of distribution from the state, and the state will be collecting, according to Amendment 3, state will be collecting 6% automatically with the passage of Amendment 3 on this particular, on recreational marijuana. And then it allows us, but we have to go to a separate vote of the people, as Mr. Zura said a few times here. But I do not think that the council should expect that there will be any appropriation of funds to the local governments. I think the 6% that they're collecting is going to be used up well before that. We have seen that by appropriation before on items like this. It's going to be, the council should expect this to be an unfunded mandate. And obviously it's going to take a considerable amount of interpretation and work going forward to get this appropriately into our code. It would be my recommendation that the council entertain putting this onto your next regular meeting in December. The reason for that is, as you know, whenever we're putting something like this on the April ballot, I don't like to run up on that Monday night before we have to turn it in to the county clerk on the Tuesday by 4 o'clock, which means that we only have 2 council meetings before that. So if the council is okay with putting this particular ordinance on, it would be on the first December regular council meeting. It would not be on this coming Monday night, but that first December. That would give us that final Monday night in case we had to make any changes or anything came to light. I would be recommending to the council, according to this particular ordinance, that it be 3% allocated to the general fund, the entire 3%. There are some locations that are distributing the 3% according to the sales tax distribution that we currently have, which would be, obviously, you can see that in that third whereas clause of the ordinance. The reason I would recommend that it go into the general fund is, again, it gives us the greatest flexibility on how we want to use that going down the road. There were some other cities that actually, similar to what we did with the use tax, outlined exactly what they were planning on applying that to and what they were going to use it for. A lot of them are in public safety, a lot of them are in public works. Again, I would recommend to the council with this particular one, because we have no idea what kind of money we're talking about here. We we can judge, I don't think it's, I was surprised at, I thought it was going to be higher when we used the medical facility as far as the sales there were concerned. As council knows, I can't share those in specific with you by state statute, but I actually thought it was going to be a higher amount than it actually is. But the only other item that might be subject to some interpretation, but I've been completely howled down by my staff in these conversations, is I will turn your attention to subsection 5. The part that says, the tax authorized by this paragraph shall be in addition to any and all other tangible personal property retail sales taxes that are on there. I had originally hoped that perhaps staff would agree with me that that means that we can do 3% on the general fund, 3% on the sales tax and the transportation fund, so on and so forth with the capital and the park and recreation one. Apparently any and all takes on different interpretations, so we're only allowed to do 1 3% rather than 4 3%. I prefer the latter, but I'm not going to get away with it. Would the council be amenable, thumbs up, thumbs down, consensus to going ahead and having this on? Terrific, and we will be.
Mr. Townsend has a question.
Thank you. I read that particular part, and I was interpreting that to mean in addition to our 2.5% plus the 3, or this is replaces the 2.5.
The early interpretations are we're allowed to charge a 3% on marijuana sales, not a 3% for each of the sales taxes that we have in place. But I like your thinking, sir. That's one for me.
Anyone else? Okay. Anything else?
Sir, I believe that concludes my report. Again, I'm happy to provide any additional questions you all might have.
Okay. Go ahead.
No, we do have the ordinance.
Yeah, one page here. You're looking at one page here of the entirety of the amendment. The amendment is 39 pages. The first half of the amendment applies to what was originally in as far as medical marijuana is concerned and any changes that are going to go in place there. But if the council would like, I can provide you with the entire amendment if any of you would want it. Just let me know. Okay, very good. Very good.
Yes, Mr.
Does this address synthetic marijuana at all?
There was information included within it regarding your Delta 8 and Delta 9 from Colorado's provisions, but not within the terms of the documentation for the amendment.
Okay, thank you.
Yes,
And there-
Jim?
I was just going to say that there's probably in the state statutes, 195 section, that we might be able to utilize depending on what it's made of, the synthetic.
That would conclude my presentation.
Anyone have any questions of Mr. Zur or staff? Put it on the agenda, first one in December then.
We'll do it, sir.
Uh-huh. So no further questions on this item. Move on to item C. As I said, it was Planning and Zoning and BZA are the appointments. There are 3 that are expiring on their first terms. Actually, Mr. Martin's been around a while, but the ones on Planning and Zoning are their first term's expiration, and so they've all been asked if they want to continue to serve, and they have expressed an interest. And all 3 have done a great job for those 2 organizations, or 2 commissions. So we're going to go ahead and put them back on for reappointment. Nobody knew. Do you have any questions? Okay. Is there any other items to discuss before we adjourn? Did you have anything else?
I have nothing else.
So we do need to go into executive session. I'd entertain a motion to move into executive session.
Mr. Mayor,
Mr. Townsend.
move that the Raymore City Council move into executive session to discuss litigation matters as authorized by revised Missouri statute 610.021 subsection 1.
Thank you. Is there a second?
I'll second the motion, sir.
Motion's been made and seconded to go into executive session per litigation matters as authorized by 610.0211. Roll
Count-
call, please.
Councilman Townsend,
Aye.
Councilmember Wills,
Yes.
Councilmember Forrester,
Yes.
Councilmember Burke. Yes. Councilmember Abdulgawad,
Yes.
Councilmember Holman.
Yes.
Very good.
Okay, and we'll be through when we get done with that. Yes.
Good night. Good night, sir.
Of course. I know. Well, try to help you guys. You sure you don't want one? Oh, you got the funny one.
Yeah,
You
I'm
got the
keeping
funny-
that one.
Good, good, good.